Alex here with a perspectives video on evidence. A camera team is in place at District Judge Rob Baer's chambers. As with our previous video, Judicial Canon 2.10 forbids the judiciary from commenting publicly on pending and impending litigation, so we'll focus on general questions with regards to this topic. Let's go ahead and get started. We are here with the Honorable Rob Baer. The theme for this perspectives video is evidence. But first, why don't you tell us about yourself and your campaign for re-election to Department 32 of the Eighth Judicial District Court?
Well, thanks, Mr. Falcone. My name is Rob Baer. I'm the District Court Judge in Department 32 of the Eighth Judicial District Court. I've been the judge here for a little over 9 years now. I've been a pretty lucky guy. I know you asked for just a little bit of background, but what comes to mind is that, I started my life in an orphanage. I was adopted by an American service couple and his wife. I was lucky to have those two wonderful people make me their son and raise me. My dad spent 27 years in the Army, and so when I graduated law school, I felt like I wanted to show him that I respected him and his service, and so I did join the United States Army. I was a member of the Judge Advocate General's Corps from 1989 through 1993. I was a trial lawyer, a captain in the United States Army. It was a wonderful experience. I was in court all the time, and I did that really to surprise my dad. He was really surprised, and it turned out that was one of the better professional decisions in my life as well, because they threw you pretty much to the wolves as a new lawyer. And anyway, I signed up for 3 years. I served about 4 years and 2 months in the Army. I really enjoyed that. But in 1993, after being honorably discharged, I showed up here in Nevada. I had heard that Nevada was the land of opportunity, and well, I assure you it's been that way for me. I interviewed with the State Bar of Nevada. I was lucky enough to be offered the job to be one of the lawyers at the State Bar. I became the chief lawyer for the State Bar of Nevada. I was the bar counsel for the State Bar for 17 years. From 1993, then whatever 17 more years is, I guess that's about 2010 or so. And there I was trusted by the Nevada Supreme Court and the board that governed the State Bar to be the chief prosecutor concerning cases where unfortunately lawyers involved themselves in unethical conduct and acted like dogs apparently. Sorry, I heard a dog barking in the background. But anyway, I was the chief prosecutor for the State Bar and did that for about 17 years. And then the legislature in its wisdom created some new judicial departments here at the 8th Judicial District, including Department 32, the one, again, I've been a judge in for 9 years. And I'll tell you the truth is that my dad passed away in 95. And he's buried in Arlington National Cemetery. But my mom is still alive now. She's 87. So that in 2010, when this new Department 32 was created by the legislature, I was pretty happy in my job I had at the bar, but I felt as though that if I could run for election and be elected during my mom's lifetime, that, frankly, she'd be pretty proud of me. So that was the primary motivating factor for me, was to run for office while my mom was alive. And I was lucky enough to be elected in 2010, be reelected in 2014. And so now this election in 2020 is my third election. 2-0 lifetime, hopefully 3-0 lifetime here the day after my birthday. My birthday is November 2nd, election day is November 3rd of this year, so hopefully that'll be a good birthday gift for both me and my mom, who's still alive and now real interested in the campaign. So that's just a nutshell version of what leads us to be here today.
So most of the hearings we cover are procedural, though the longer ones tend to be evidentiary. While assertions are raised at virtually any hearing that comes up, the viewers often struggle with the distinction between the judge making decisions based on what he's told at a procedural hearing versus the findings of fact made at a trial or an evidentiary hearing. Would you be able to elaborate on the distinction and perhaps the purpose of the different types of hearings?
Well, there's a number of types of motions and hearings that come to the court's attention prior to trials. I think that's what you're getting to. There's motions to dismiss, motions for summary judgment, and then specific to the trials, oftentimes there's a body of motion practice called motions in limine, where certain evidentiary issues are decided. And so I don't find that there's much of a distinction or comparison to mention other than if you're asking me to talk about the difference between pretrial motions and those that arise during trial, there's probably a distinction there. The good part about the pretrial motion activity is that there's a schedule whereby the lawyers file pleadings and briefs, and there's time then for me to read the pleadings and briefs and consider everything, and then have court knowing full well 100% what all the factual contentions are, what all the legal issues are, what standards of law to apply either from statutes or from case law. So there's plenty of time to prepare and deal with all that. Whereas during trial, it's not always that way. During trial, there's a number of evidentiary issues that come up that you deal with without that much time to prepare for them. But the good news on that is, frankly, experience is a great teacher. And now that I've been a judge 9 years, you're, I think, with experience, better able to anticipate the evidentiary issues that can come about during trial. In fact, I regularly do that. It's just something that comes to you, again, given the experience that you can have as a sitting judge. You go through the jury trial, whether it's a week, 2 weeks, a couple 6-week trials we've had, and you start to think about, as the trial progresses, what are the potential evidentiary issues that may come up, given your understanding of the theory of the case brought by the plaintiffs, the affirmative defenses or defenses that the defense has, the facts of the cases they then play out in front of you. So I try to anticipate what may come up and pull case law or statutes or remind myself of various evidentiary issues that I've dealt with in the past. And then when they come up, I'm prepared to address them more specifically. But there are always those things that do come up during the course of a jury trial that might necessitate some additional briefing or some thought at lunchtime even or overnight, and then you deal with them in that case. But that's pretty much the difference between all the pretrial activity and things that you deal with live as a jury trial is going on.
There was a lot of detail in that answer, and that's great. That's typically what we're looking for. It's much appreciated. Some have wondered why we don't provide coverage of settlement conferences. To what extent are settlement negotiations confidential, and perhaps more importantly, why?
Well, as a civil judge, I have done, I don't know how many settlement conferences over the years. I haven't kept track specifically, but it's been a number of them. I don't know if it's 50, but that number comes to mind as an estimate over 9 years. I do know that the court came up with a new protocol for the year 2020 where the court system has asked that we find 12 days throughout the calendar year and let the administration know about the 12 days that we'll do settlement conferences. And I, months ago, provided, along with my staff, the 12 days. So I know we have 12 settlement conferences set for the year 2020. I pretty much always say yes. I don't think I've ever said no when parties mutually have asked me to do a settlement conference. And that's probably been about 20 times over the years, where both sides in a civil lawsuit will ask me to do a settlement conference. And again, I always say yes to that and find an afternoon usually available to do that settlement conference. I mean, they're a meaningful part of what we do here. I think every week the court system has probably 3 to 5 settlement conferences in civil cases that judges volunteer for or the senior judges handle. So I hope that answers your question.
Yes, for the most part. We just got two more here. One of the most common questions we get from the public has to do with the testimony of witnesses. It is a surprise to most of our viewers that testimony counts as evidence. Would you be able to offer any insight?
That testimony counts as evidence? Testimony from witnesses in trial? Well, of course that's evidence, if that's what you're asking.
Right, to the legal system it is, but I think most of the questions I get have to do with people imagining that evidence is something physical, like photographs or documentation. It was just an opportunity for some insight from you on that, perhaps.
Certainly, given that context, certainly testimony of witnesses in trial, frankly, that's a huge part of what the juries consider by way of evidence. In fact, I think that really goes to one of the reasons, frankly, it's so cool to be a juror. In fact, if you look at my website, judgerobbear.com, you can see I decided to put up on the website just the other day 7 testimonial letters that were unsolicited by me from those that were summoned and served on juries in our courtroom, some for a week, some for 2 weeks, some for longer than that. Just since the last election cycle. So there's 7 letters up there that jurors have written to me after they've been jurors in our trials. And again, at judgerobbear.com, you can look at those letters. Those letters are reflective of what really does happen here in Department 32 with our juries. It's, I think, a wonderful experience. So we respect the jury's time. And it's a rather involved mental exercise for jurors. And this is one of the things they do. It's their job and their job alone to decide the facts of the case. The judge does not decide the facts of the case. My job is to provide them with the relevant law that applies to the facts of the case. But the jurors are the most important ones in the room, and that includes me. They decide the verdict, they decide the facts. And so part of what they have to do, that's an interesting mental exercise, no doubt, is assess credibility evaluations for these witnesses, decide who to believe, who not to believe, how much weight to give to live testimony. So you could probably ask jurors, but they'd say that the most important aspect of all the evidence, if you will, of the case, really is the testimony of the witnesses. Certainly there's tangible evidence as well, documents and what have you, records that may come into evidence that the jury considers. But I'd say, and it's an interesting thing, I never really thought about it much, but I bet you that the live testimony of witnesses is what wins or loses your trial at the end of the day. And that's up to the jury to, again, give whatever weight they want to that live testimony.
I think the answer you gave is going to be extremely helpful. So last question. Many understand the general reasons as to why some issues during a jury trial are resolved in limine, as you mentioned earlier, or outside the presence of the jury, but some are curious as to where the distinction is drawn between the jury giving due weight to a piece of evidence versus evidence being withheld from the jury in its entirety.
Well, my answer to that question is typically, and this goes to one of the primary roles, I think, of a judge, is to not do anything that would confuse the jury, not allow things to happen in the courtroom that could potentially be confusing to the jury. So my thought is that any out of the presence of the jury decisions that the court makes, these motions to allow evidence or not allow evidence, motions in limine, if you will, to maybe limit what an expert witness can say, or other evidentiary issues. Typically the jury, for reasons that make sense, really is not told of, nor will they ever really know of, the decisions made without them in the courtroom having to do with evidence. In other words, if I decide that an item of evidence is not allowable, in some motion practice that comes before the court outside of the jury's presence, I make that decision. But typically we intentionally, frankly, don't let the jury know about that because we don't want to confuse them. And the reason that it could be confusing to them is let's say I disallowed a certain line of evidence that's a tangible item, a document, records, or let's say I limited or disallowed or precluded a witness's testimony. We wouldn't want to let the jury know about that because chances are the jury would try to figure out, well, what about all that? You know, the judge decided to not allow that evidence, and so why did the judge do that? And we don't want them to get confused or involved with that and sort of, you know, second guess whether the evidence should be used or the witness could be allowed or not. Now, what I do, though, is in the, I don't know how many jury trials we've had since I've been here. Again, that's probably 50 or more. I don't know what it is actually, though. But we always meet with the jury when the case is over with. In other words, I have the jury go back into the deliberation room, and then along with counsel, we meet with them. And it's at that time that we will typically, I do, and the lawyers can too, they're welcome to. We do explain a lot of the stuff that happened behind the scenes that we intentionally dealt with without involving them so that they're not confused. We might talk about evidence that was disallowed or witnesses that were either disallowed or some of their testimony maybe being limited. In fact, in my courtroom, I allow the jurors to ask questions to the witnesses. And those questions, about 90% of them were asked by me, but that does mean about 10% of the time on average, the questions posed by jurors are not allowed. But what I do is I keep a copy of all the questions that are not allowed. And again, it's only about 10% of the jury's questions. And it's at that meeting after the court, after the verdict comes in, the meeting with the jury, I'll go over the questions that I disallowed that they asked and explain the legal reason why they weren't asked. And that, again, is an opportunity further to explain anything else that happened behind the scenes that might have affected the evidence and the trial itself, and just let them know the reasons for that activity as well. So I hope that answers your question.
It really did. Thank you so much for coming on, Mr. Bear. We really appreciate it.
All right, thanks a lot.